Welcome to the Negotiation in Real Life podcast. I'm your host, Nicole Davidson, and in this podcast, we'll explore the art and science of negotiation in real-world situations. Whether you're negotiating a business deal, asking for a raise, or trying to resolve a conflict with a colleague or loved one, negotiation is an essential skill that can help you achieve your goals and build better relationships. Through interviews with experts, real-life stories, and practical tips and techniques, we'll deep dive into the strategies and tactics that can make you a better negotiator. From understanding your own negotiation style, to reading body language, handling difficult conversations, and overcoming common challenges, this podcast will give you the tools you need to negotiate with confidence and achieve your objectives. So whether you're a seasoned negotiator looking to refine your skills or someone who's new to the game, join us as we explore the world of negotiation in real life. It's a pleasure to be joined on the podcast today by Natasha Hannah. Tash, welcome to the podcast. It's a pleasure to have you on board today.
Thank you. Thanks for having me.
Well, I know that you have lots of really interesting stories of difficult situations, being a person who focuses on employment law disputes, and we're going to get into those. But perhaps before we do, you might like to give our listeners a brief overview of who you are and what you do.
Yeah, sure. So my name's Natasha Hannah. I am a lawyer and director of In-House Nous, and we are an employment law and commercial law firm. We started the business last year, and essentially we started it because we wanted to create a place which aligned with our values. The places we worked before just never felt like the right fit. And for us, it's about being who we are as humans when we come to work. And so we started a firm where we could do that. And yes, as you said, my practice is in employment law, and I have a raft of experience dealing with all sorts of interesting issues, including in the Fair Work Commission, where I do a lot of conciliations.
Fantastic. And I love, you sort of didn't mention it specifically, but In-House Nous comes from the fact that you and your partner have both worked as in-house lawyers and have that perspective of sitting in what is generally the client's shoes. How does that make a difference to the way you approach the negotiations that you have on behalf of your clients?
Yeah, that's a good question, Nicole. So yes, that's right. We both have worked in private practice and then went in-house for a little bit as well. So being in-house within, the legal team or the HR team within a business. So yes, you're right. I do have that perspective of what it feels like being on the inside, dealing with, all the different stakeholders and how they feel about a scenario, potential budgetary constraints that might hamstring you when you're dealing with an issue. So I definitely feel like that experience has been helpful then coming back on the outside. And as part of our business, as you said, we offer outsourced in-house counsel. So essentially work with businesses who don't have in-house counsel, and we fill those shoes, if you like.
Yeah, I love that. And I think the fact that you've been in the client's shoes is such an important thing for the client to understand, because it does bring a different perspective, I think. I want to step back a little bit. Obviously, as lawyers, one of the things that's not taught in law school is how to negotiate. We sort of have to learn along the way. I wonder if you've had any interesting experiences along your career that have really impacted either positively or negatively on the way that you negotiate today.
Yes, many stories to discuss. I think it's a bit trial by fire, and you're right. I mean, in law school you do have a couple of moot courts, if you like, and experiences, but they're never really anything like in real life. I mean, I often think about the first time I had to appear in court and got absolutely no background. I was just told to go get some documents that had to be produced. I can't even remember the details. And essentially the judge just completely reprimanded me for not knowing what I was doing. So that was really fun and scarring.
Oh, don't worry. I had a similar experience. I remember appearing before the listing master for a file that I knew nothing about, and he tore shreds through me. And he's like, you go back and you tell that senior associate that they shouldn't have done that. And I'm like, okay. Yeah,
they don't. I mean, there's not really a lot of time and patience even for the poor juniors, unfortunately. But yes, in terms of conciliations, I was very much thrown in the deep end as well in those. But I guess being a less formal process, it wasn't as daunting. And at the time, my first role where I did start doing conciliations, I was in an environment where they were really encouraging. So it was okay to make mistakes, which was good. And, you learn. I think it is a bit trial by fire. You learn through the mistakes you make, even unfortunately, in the scenario where you're dealing with live issues, because it's the only way to work through it. When, as we know with law generally, you just have to apply the law to a situation and start learning how it works in practice. And I think conciliations and negotiations are unfortunately no different.
Yeah. So are there any particular things that you remember where you've gone, oh, that was a big lesson, I'm going to do things differently?
Yeah, I think it sort of sounds basic, but really just preparing both yourself and your client before the conciliation or mediation.
Yeah.
Probably just naively in my early days, I think I went in just sort of with a high level, hey, this is what's going to happen, these are the issues, let's just see how it goes kind of thing. And now I very much walk my client through the journey of what's going to happen. So preparing the expectations before we go in, I think is really, really critical. Challenging some of their assumptions around what they think is going to happen, particularly dealing with employees, obviously, which is very emotional, what the employee's likely to say, how they're going to react. And that's all based on the experiences I've had to date around how things turn sour. So I really, spend the time to prepare the client and myself. I'll do a briefing for them where I tell them about my thoughts of how it may go, the strengths and weaknesses. And then, of course, we talk about, commercial outcomes and what that might look like and where, they're happy to start and end, ideally, if we can put that together. And every client's different in what works for them and where they're prepared to go. But I think that over time, that has been a skill that's become really important, and you just don't know until you sort of realise that lack of preparation really is not helpful.
And that's the thing, isn't it? And look, I always say it's 80% of your success comes from the preparation. But I think it's knowing what preparation is, because I think, as you said, when you're younger, you think that preparation is just knowing the facts, but it's actually the emotional preparation, the psychological preparation. And what you talked about was actually, let's prepare our client for what the other side might say and how they might respond. So preparation is not just about you, but it's about the other party as well. So I think that is a really important lesson for people to take away. So a little bit more specifically, obviously, employment disputes, I don't know, it seems like they're on the rise. I may be wrong, but it's pretty common now, and we're getting a lot of disputes around things like people who aren't getting flexible work arrangements the way they want them, or they're not being able to work from home, or various things. And I know you work typically on the employer side, the majority of your work. My understanding and sort of the experience that I've had is often these things get to places like the Fair Work Commission because there might have been flaws in the negotiations at the employer level. What are some of the mistakes that you see employers making that end up with a situation having to go to a formal process like the Fair Work Commission?
I think it comes down to really the employee not feeling heard at the outset. And so, you have your processes around a particular issue, and they obviously have to be followed as well. But it's more than that. It's a holistic view of whether or not the employee has a legitimate claim. Are you making them feel heard? And I think a lot of disputes can be resolved if there was just a little bit more cooperation, open-mindedness about where the employee is coming from. And, some of the processes, particularly the new process for disputing a flexible working arrangement request, they require the parties to take avenues to resolve the dispute internally first. And, every employee is different in how they approach it. But if you fail to, take advantage of that opportunity, it really is a loss, I think, emotionally for both parties, because it's the time and energy of going through a dispute is enormous. It's really underestimated. I say it every time. I feel like I sound like a broken record when I talk to clients, because
I think that's probably the time, the energy and the cost.
Yeah, and of course the cost, paying us lawyers, who wants to do that? So, but it can really be avoided if you take advantage of those early intervention options and the ability to resolve the dispute before it becomes too heated. And a classic example as well outside of the conciliation context is, a work cover claim, someone who might have a stress or, bullying related issue. They don't feel like they're getting anywhere, so they start looking at work cover claims, anti-bullying applications, etc. That's just another example where employers aren't catching it early enough by simply just making the employee feel heard, I think.
Well, it's interesting, isn't it? Because some of the work that I get is actually coming into those situations as the external. Often I say, let's not call it mediation, let's call it facilitation, because it feels a bit less scary. But that takes into account that sometimes the employers just don't have the skills to go into that conflict, or sometimes the relationship is already sort of teetering on the edge of unworkable, so that it's really difficult to have those conversations. And, one of my constant refrains, sounds like I'm touting for business now, but, actually bringing in an external who's got those skills to facilitate those conversations, I see as an investment in avoiding the legal fees down the track. I'd be interested to see, as the lawyer, what your take is on that.
I completely agree. I think, I have my skill set, but I do think that there is definitely a time and place for the experts to be called in. And I agree with you. If there's an opportunity, you might within your team, for example, even have some HR business partners who are really good at facilitation, great. But if you don't, get someone who can do it. And just like you said, creating that opportunity to facilitate a discussion, a meaningful discussion, both parties feel heard, both parties have the opportunity to say their piece, and hopefully you can resolve it. Yeah, so I'm with you there. Yeah.
Yeah, and it's interesting because often there is that sort of HR aspect to it. But once again, you've got to be really careful that the HR person is perceived as neutral and not on the company side. And that's the real struggle because, the employee can very much feel like they're not on my side.
I think that's an important consideration. In fact, that's a really good point you raise, and I agree. No case is the same, obviously, but in situations where you're right, the HR manager may not be viewed as neutral. Sometimes they're an ally, sometimes they're not. And there's various reasons for that, why an employee might feel like everyone's against them. But, I think, you're right. If the employee does feel like they need that independent third party, then you should definitely engage someone. And even with that, it can be difficult because they may feel like it's still someone who's coming in to support the employer. But, you can only do what you can do. Definitely calling it where you think it's appropriate to have someone come in. I agree.
Yeah. And look, I think regardless of whether that independent person is internal within the HR team or whether it's an external person, their job is to have the discussions with the employee to confirm that they are comfortable with it before the process goes. Because I think, once again, if you go through a process and the employee is feeling like they've been pressured into it and they're not really buying into the process, you're actually just escalating that conflict because now it's not just, and you often say you've got one thing that happens in the workplace, whether it's a discussion where the employees, let's say they're not getting their flexible work arrangements, that's complaint number one. Then it's like they feel like they haven't been heard. So now they've got a second complaint. And it becomes really much more complex because there's this whole range of process complaints that they've got that add on to that one initial thing. So what started as something that was relatively small escalates to the point of, explosion.
It snowballs really quickly. It really does.
So let's assume that the employer hasn't been able to resolve it and it does end up in the Fair Work Commission. What are the key things that you help people through in terms of negotiating at that point? Because obviously there's, generally mandatory conciliation. What are your top tips for somebody who's going through that process?
Yeah, so I think, if you have engaged counsel, if you can, it's really wise because it's, as I said at the outset, important to understand what you can expect going in. And look, the Commission has some really great information on their website about the conference process. They've really over the years made an effort to educate, which is great. But essentially preparing yourself for going into that conciliation emotionally. Also, from a legal perspective, what are the strengths and weaknesses of your case? And therefore, are you going in with some sort of commercial settlement in mind? And the first thing, in fact, I usually say to my clients is going in, regardless of the strength of your case, do you want this, do you want this to be done? Do you want this to go away? And I guess think about carefully what a commercial settlement might look like to help you basically put this behind you. And most recently I had a matter, I think I might have told you about it, Nicole, in a separate conversation, but where the client had a strong case, and if it went all the way, they probably, they had a good chance of success. But regardless, I could already see it taking a toll on them. They were, quite upset about the process. They actually felt quite disappointed that the employee had brought a claim where they, in circumstances where they'd actually given them quite a lot of support during their employment. There were some various issues, but it just didn't work out.
Yeah.
And so they had to essentially have some deep conversations internally around, well, regardless of the strength of our case, we want this to go away. What are we willing essentially to go into a conciliation and potentially pay this employee for it to go away? And, again, it looks different in every matter, but I think some of those things are really important to think about going into the process.
I think that's so important because, particularly in a small business, I think the stress and the impact on your ability as a business owner to do the other things you need to productively manage your business can be really impacted by getting distracted by this legal case.
Mm-hmm. Mm-hmm.
And, it's one of the things that I often talk about when I'm in mediations is, because if you're a small business owner and you've got a case that feels, you're being told you've got a really good chance of success, you've done nothing wrong, and yet you're going to have to pay money to go away, it feels really unfair. This is, I talk about the fact that we don't have a justice system, we have a legal system, and those two things don't really necessarily align. And it's a hard thing to swallow.
It is. And, as, the representative or the lawyer, it's really hard to see your client go through that. It really is. Like we often feel like, you're trying to say to them, I am on your side, I get it. But also the experience I've had is that, most people just don't want to go through this process all the way. It's very taxing, and I find that generally we start somewhere, where the client is kind of, let's do this, let's, play our bluff, let's play their bluff, let's, see what we can do if we can manage to get away with paying very little, et cetera. And they start off really kind of not litigious, but willing to get in there and have a bit of a fight. And ultimately, after, a couple of hours of negotiation, they're over it. I see it every time. And as the process continues, particularly in the court context, I mean, that process is just protracted and exhausting and costly. There's a lot more process and procedure, as you know, and the client just gets over it. And so I feel like, my job is trying to give that context and set those expectations, but often the client just has to see it for themselves.
And I think that's one of the challenges, isn't it, that they haven't been through it. And if they knew what was coming, they'd probably settle earlier for the same amount that they're going to end up settling, but without having paid as much legal fees along the way. But it's really difficult for them to see that. As you said, I think there is a certain degree to which they've got to understand the pain, and part of my goal is to make them understand that pain without having to go through it, and sharing stories of those. But it's also, I think there is a systemic problem when some of these employees may well just be having a go, knowing that they'll get money to go away. And, I don't know how we change that in the system, because that's where the unfairness is coming from. And I don't know to the extent that some lawyers might be utilising that to their own advantage, to say, well, look, you're not going to win, but let's bring a claim because you'll get something.
Yeah, absolutely. I think unfortunately, that is an accurate statement. It's true. There are plaintiff lawyers, the lawyers who represent employees who are out there doing that because they get a paycheck. And I find I actually really feel sorry in some cases where the employee doesn't have a great claim and they've sort of got themselves a lawyer and they've got fees racking up and they basically have to settle because they've now got a bill. And I feel like that is really wrong, but it does happen. And then the other difficulty, so there's sort of that pressure of paying a lawyer on the side of the employee to deal with. And then you've also got essentially employees who just emotionally, they're not doing well. and they can't see through the matter rationally. And so you're essentially negotiating against a ball of mess. And it's really challenging.
Well, this is the hard part, isn't it? Because if someone's in that position of extreme stress, their brain is not actually allowing them to make the rational decisions that they need to make. So you've got, and you know, the conciliator or the mediator or the lawyers on either side need to be able to work with that somehow and help them through that. I'm going to run an idea past you because I've sort of pushed this idea from a commercial perspective, but I'm interested to know what an employment lawyer would think about it. You know, I think one of the problems is that we're working with this adversarial system that we inherited from, you know, hundreds of years ago, which was designed not for commercial or civil disputes, but it was designed for criminal law. And I think it's got a place in criminal law. But my thinking is if you were to create a system today for resolving business-related disputes, it probably wouldn't look much like the adversarial system. And so I actually see a system that's a little bit more like the inquisitorial system where a dispute is brought to a neutral whose job is to work with both of the parties to have those sort of facilitated negotiations up front to see if resolution can be resolved. If not, the neutral person's responsible for going and getting an independent legal advice rather than having two lawyers with different perspectives because they're going to favour their clients, so that you get one piece of neutral advice that's then used to try and help facilitate the settlement again. And only then would it go to some sort of adjudication process. So I'd love to know your thoughts on an idea about that sort of process.
I love that, yeah. And I think you're right. The difficulty is that obviously you know, a good lawyer would tell their client the weaknesses in their case. But of course, as you said, you know, both party believes that they're to an extent right. And so, you know, even the one I was in recently, I, you know, sort of pushed a particular argument and I said to the client, like, we're right with this. We're right. There might be other weaknesses, but this we're right. And it just didn't really make an impact, particularly because also the conciliator was kind of just sitting on the fence a little bit. And it's really frustrating. So I think if you had an ability to, have someone sort of come in from the top, a third party, unbiased, and really be able to throw their weight around, that would be wonderful. Help the party see perspective.
Well, and this is the interesting thing because there's been plenty of research studies done that will show that if you give the exact same fact scenario to two lawyers and tell one that they're the plaintiff and one that they're the defendant, they will interpret that fact scenario completely differently.
Of course. Yeah.
And this is where I think, you know, as much as there is a position for lawyers in these situations, having the lawyers as a neutral arbitrator or a neutral advisor rather than each party having a biased, you know, subconsciously but still biased lawyer, and putting the lawyers in after the neutral with that sort of lens could make a huge difference for the users of the system.
Yeah, I think just the ability where you get a good conciliator, it's so helpful for me to do my job because I'll say, well, you know, the conciliator is saying, that they agree those weaknesses are real, and it's so helpful for me to then do my job, particularly if the client's sort of not seeing the wood from the trees.
Yeah. Fascinating. Excellent. Well, look, I've really enjoyed having a chat to you about these issues, and I'm sure we could come back and talk about lots more, but I'll keep it to time for our listeners today. If our listeners wanted to get in touch with you and have a chat about some employment issues or anything else that might be of interest to them, what's the best way for them to contact you, Tash?
Yeah, sure. So you can jump on our website, www.inhousenous.com.au, and there's a contact form there that you can get in contact. Otherwise, please feel free to connect with me on LinkedIn. I'm Natasha Hannah. I think it's Natasha Hannah AU. If you put that in, that should come up. But more than happy to connect and chat.
Fantastic. And we'll put all your contact details in the show notes as well. So thanks again for coming on the show. That's all for this episode of the Negotiation in Real Life podcast. I hope you enjoyed our discussion and learned something new that you can apply in your own negotiations. Remember, negotiation is a skill that can be developed and refined over time, so keep practicing and pushing yourself out of your comfort zone. If you have any questions, comments, or suggestions for future episodes, please don't hesitate to reach out. You can find us on social media or email us directly. And if you liked this episode, please leave us a review on your favourite podcast platform. It helps us to reach more people and continue to produce high quality content. Until next time, keep negotiating in real life.